Hello, I'm Andrew Kingsdale, a transactional associate at law offices of Omar, Figueroa. Today, I'm going to talk about recent updates to California's industrial hemp laws with the passage of SB 153 on October 12, 2019. This hemp cultivation bill amended California's existing industrial hemp laws by bringing them more in line with federal requirements for state hemp plans under the 2018 Farm Bill. With SB 153, California's Department of Food and Agriculture now has a new deadline of May 1st, 2020 to submit California's state plan to regulate hemp cultivation to the United States Department of Agriculture for their approval. Some other substantive changes under SB 153 include adding new enforcement penalties for negligent and grossly negligent conduct by hemp farmers, and adding new eligibility conditions to become a registered hemp grower. So, for example, a controlled substances felony conviction could disqualify somebody from registering as a hemp grower in California. SB 153 also created new agency reporting requirements. Now, each county agricultural commission or department, which are responsible for registering hemp growers within their borders, must report hemp growers' information to the California Department of Food and Agriculture, which then reports that information to the United States Department of Agriculture. It's important to note that until California has a USDA-approved state plan, or until the USDA finalizes its own rules implementing the 2018 Farm Bill, which is supposed to happen later this year, federal law only permits California hemp cultivation under the 2014 Farm Bill, which limited approved growers to research institutions only. SB 53 updated the state's registration process for these research institutions. Another significant change under SB 153 is that any industrial hemp cultivated on land that is licensed by Cal Cannabis for commercial cannabis cultivation will automatically be deemed cannabis and therefore subject to more stringent cannabis laws regardless of the THC levels in that hemp. And that's now in Food and Agriculture Code section 81006. Finally, SB 153 adds certain registration requirements for hemp breeders, which are formerly called seed breeders, and are now distinct from the growers of industrial hemp. Hemp breeders are defined as entities that develop cultivars intended for sale or research. Under SB 153, hemp breeders will have to submit what's called a variety development plan to their local agricultural commissioner. The plan will have to include the hemp varieties that will be used, a plan for testing all the plants that are grown, and measures to destroy any plants with THC levels that are above 0.3%. In summary, with SB 153, the differences between California's regulation of industrial hemp cultivation on the one hand compared to cannabis cultivation on the other will remain quite stark. While hemp farming is already a competitive industry here in California with over 30,000 acres of hemp farms already registered, hemp farmers do benefit from lower barriers to entry, including lower registration and licensing fees, a relatively streamlined application process, and fairly minimal testing requirements. That is, testing for THC content only as compared to the many pesticides and other contaminants that must be tested for cannabis. Furthermore, federal legalization of hemp under the 2018 Farm Bill has opened numerous doors to hemp farmers relative to cannabis growers. For example, hemp farmers have better access to banking. Cannabis businesses are heavily scrutinized by banks and reported to the U.S. Treasury Department through suspicious activity reports. By contrast, suspicious activity reports are not required to be filed for lawfully operating hemp-related businesses, according to the National Credit Union Administration. The U.S. Department of Agriculture is taking other steps to support hemp farmers as well, such as making federal crop insurance available and accepting applications of seed-propagated hemp for plant variety protection. And of course, hemp benefits greatly in other critical ways, too, such as federal trademark protection, the right to interstate transportation, and no tax headaches from Internal Revenue Code Section 280E. Overall, it's a promising regulatory outlook for California's hemp farmers. On a side note, hemp product manufacturers have not been quite so fortunate. AB 228, which circulated earlier this year, would have expanded opportunities for hemp product manufacturers, in particular by specifying that foods, certain beverages, and cosmetics are not, quote unquote, adulterated by the inclusion of cannabinoids and other industrial hemp extracts or derivatives like CBD. But AB 228 never made it out of the suspense file, and that pathway is dead for now. That's all for today. If you would like some more information or any assistance with registering or growing your hemp business, please contact the law offices of Omar Figueroa at 707-829-0215 or email us at info@omarfigueroa.com to schedule a confidential legal consultation. Thank you and have a great day.